Hey again everybody, this is Phil with Arete Law, and this is value video 2 of our value video series in the 3 emails that we have been sending you to give you more knowledge and more information about choosing the right estate plan for you and which one is best for you and your loved ones. Today's question is probably the most important question when it comes to drafting your estate plan, and is whether you want to base your estate plan on a trust or a will, and what is the difference between the two of them. So what we're going to discuss today is what is a will, what is a trust, the pros and cons of each, as well as some questions you can ask yourself that will help you determine which one is right for you. So the first one is, what is a will? A will is probably the most basic estate planning document. There's nothing wrong with it. It does provide protection. It does give your wishes as to what you would like after your passing. But it is a base estate planning document, meaning it's the base of a lot of estate plans, is the base of even just a will-based estate plan. It's not the only document. When it comes to a trust-based estate plan, it's included as well, but it works together with the trust. But if you do it all by itself, it's probably the most basic and minimal amount of protection you could provide when it comes to an estate plan. Nothing wrong with that. For a lot of people, it does work, but it is the most basic and does provide the most minimal protection. A will dictates what you want done by what is called an executor. An executor executes your wishes. So you would pick someone who is going to execute your estate, meaning how you want stuff distributed, any sort of different instructions that you may have. It can talk about who's going to get what kind of personal items, maybe the property and stuff like that. And the executor is really bound to kind of follow that. It can discuss healthcare and minor children. A lot of those forms that you may download off of Google and LegalZoom, they're not really the greatest. They're kind of basic. They may be a little short, and you kind of just fill in your name and stuff and just kind of sign it, but it doesn't really provide a lot of protection. Of course, our templates and our wills are completely compliant with California law, as well as they run the entire gamut and cover pretty much everything. But they can discuss healthcare and minor children, which is important when you do have minor children. What is a trust? A trust is a more complex estate planning document. It is a little bit more complex because it's a legal entity, and you do have to abide by a certain California statute when it comes to drafting your trust and how you structure it. I'm going to talk about that in a minute. When you draft a trust, you are the original trustee. So that means when you draft what is called a revocable living trust, which is what we go with on our trust-based estate plans, you are the original trustee, and you appoint what is called a successor trustee. And in most cases, we suggest that you have an alternate successor trustee and a backup to that alternate successor trustee, because you can never have too many people who you can be sure are going to take care of things. So a revocable living trust allows you to amend it, change it. You can even terminate it. You can add people, take people out, put property in, take property out. And that's what a revocable living trust is. A trust is a legal entity that you do place your assets into. So you actually do treat it as a legal entity when you're a trustee. So you do have to put your assets, what is called funding the trust. You do have to fund the trust. So if you have a house and you want to put it in the trust, you do have to retitle it and put it into the trust. As opposed to a will where you don't have to retitle anything, but you're not putting anything into a will legally, so that it is protected by that legal entity, like in a trust. Now, the pros and cons of a will. It's great for a simple or smaller estate. So if you have a small estate, you don't really have property or anything like that, then it's great for you because it just gives your wishes of how you want your estate distributed, who you really want to be taking the reins after you pass away. So it does give you that peace of mind that you will have those things taken care of. It is more cost effective. Again, because it is a more basic document, it is more cost effective to get a will-based estate plan as opposed to a trust-based estate plan, which we're going to talk about. So if you're looking for something, you want protection, you could go with a will. It is the most cost-effective solution. It will give you that peace of mind that things are going to be taken care of after you pass away. First con of a will is it does not avoid probate. And this is the most important thing to keep in mind. I don't think a lot of people realize. As a probate attorney myself, I can tell you right now, if a will, after you pass away, a will still needs to go to probate in the state of California. And that means you have to file a petition with the court. And in most cases, at least here in San Diego, it could take at least 3 to 6 months before that petition is even heard. And then by that time, that's only to give you the legal authority to start administering the estate. So once you start administering the estate, there are all these different forms and things you have to file and notices you have to send out. So it can get pretty complicated. So you may have sacrificed complexity by going with the simpler document in the beginning, but afterwards it's going to be a lot more complicated. Most probate attorneys, we don't practice this way, but most probate attorneys will do what is called statutory commissions, where they'll take a percentage of the estate. So they could take a good chunk of your estate by the time they're done just for doing probate. So in the end, it may actually cost you more to just do a will. It doesn't give you the same protection as a trust. Like I said, a trust is a legal entity. So when you put stuff into a trust, it's a little bit more protected than a will. Pros and cons of a trust. First and foremost, it does avoid probate. So it's like in Monopoly when you get that card that says you can go directly past go and collect $200. You don't have to worry about going to probate. You're not going to spend money on probate attorneys. You can go right into administering the estate. Your successor trustee can jump right into administering that trust and executing your wishes. You may need a probate attorney to help with some things, but in the end, you're not really going to spend as much when it comes to probate attorney fees or going through the whole lengthy probate process, which could, again, take up to a year. It does offer more protection. Because it's a legal entity, it does provide a little bit more protection than a will because you're putting stuff into the trust. Your house is now in the trust. You know that it has to be distributed a certain way out of the trust. And in that sense, the trustee, the successor trustee, is legally bound to follow the trust exactly. So you have that comfort and that protection knowing that it's going to be administered correctly. It is more costly. That's the first con most people see. It is a little bit more complex to draft a revocable living trust because you do have to go through the formalities of making sure the trust is properly executed, that it's notarized, that it is constructed properly. So there are laws and statutes that will recognize the trust. Otherwise, if the trust is not drafted correctly, it can be voided after your passing as an invalid trust. So you have to make sure it's done correctly. So it is a little bit more costly to do it rather than a will. And asset transfers. A lot of people, if you aren't really keen on the idea of having to maintain a trust, they have to retitle. So when you do put property into a trust, you do have to technically deed your property into a trust. So here at Arete Law, part of our trust package, we do include a deed for your property into the trust, but you still have to go through the actual process of recording it and quit claiming your house into the trust. So that could be a little cumbersome for some people and kind of turns people off because they don't want to deal with the whole retitling and maintaining it. So what's right for you? And these are the questions I usually ask people, and it's a good way to gauge which one you're going to need. First one, the size of your estate. How many assets do you have? Again, if you don't really have a lot of property, maybe you're younger and you're just renting, I would suggest going with a will-based estate plan because a will give you the protection of telling people what your wishes are after your passing. Maybe you can give directions on what you want to give to certain people. But that would be how you kind of start off. Do you have a larger estate or do you have a smaller estate in sense of how many assets do you have? 2, do you have a family? If you have a spouse, you have minor children, I usually recommend going with a revocable living trust, especially if you have property and you have a spouse and minor children, because the trust will set up certain legal procedures to happen that protect how things are distributed. For example, it does, if you pass away, it goes into a surviving spouse trust, and then that happens, and then there's beneficiaries, and things are followed a little bit more rigorously when there is a trust in place. So I usually suggest if you have a family and property and stuff you want to put into a trust, just go with a revocable living trust. 3, cost. Obviously, the most important question that everybody is always questioning or asking a question about, and you have to decide what's the most protection you want at your budget. So if you want sort of a basic amount of protection and you're not looking to spend a lot of money, of course a will is a great choice. It does give you that protection. It does give you that peace of mind. If you are looking to spend a little bit more and get more protection because that's what's important to you and you can afford it, go with a revocable living trust that does give you more protection and more peace of mind. Finally, age. Usually going back to the other questions, if you're younger and you're renting, you don't really have a lot of property, the most simplest thing you could do is at least set up a will-based estate plan. Gives you all the peace of mind that you need to know. If you are older and you have amassed a large amount of assets and properties, definitely go with a revocable living trust, because a will still have to go through probate and it could be contested and people can come out of the woodworks and it can just get messy. So it's better to put everything in a trust. So that's it for this video. There's one more video. We're going to talk about the living documents. And those are the documents as in the documents for while you are living. Not all documents when it comes to estate planning are just for when you pass away. These are actually documents about when you are living. So if you're ready to hop right in and schedule a consultation, you can go with the calendar link below and you can book directly into my calendar by selecting the day and the time that is convenient for you. You can just call our receptionist at the number on the screen. They're available 24/7 for you. They will pick up the phone at that number. And if you have a general question you want to shoot over to our law firm, you can just do the info at arete.law. Someone will get back to you as soon as possible during working hours. And until the next video, thanks for tuning in, and we'll see you on the final one. Keep an eye out for it. Thank you. Have a good one.